We will now proceed with case State v. Sublett 127991. Counsel, you may approach.
May it please the court, Clayton
Go ahead. Yeah.
May it please the court, Clayton Perkins appears on behalf of the defendant appellant, Doniel Lee Sublett Jr. I would request 3 minutes for rebuttal.
Okay, 3 minutes will be granted. You may proceed.
At its core, I think the issue in this case relies or focuses on two distinctions or two areas of distinction. The first is inherent in the definition of mitigating circumstances, that mitigating circumstances are those extenuating circumstances that might justify a less severe sentence, but do not justify or excuse the offense. And the second distinction here is about the terms substantially impaired, which is the language used in the subsection A6 mitigating circumstance, versus substantially incapable, which is the term used in the voluntary intoxication or involuntary intoxication defense language, versus unable to, which is language that is typically associated with insanity defenses to the legal offense. And what I saw in this case, as I looked at Judge Ryan's ruling, was that instance after instance where we got to the mental culpability statutory mitigating circumstances, which asked this question was the defendant's capacity to appreciate the criminality of their conduct substantially impaired, or to conform the defendant's conduct to the requirements of law, was that substantially impaired? What I saw was a redefining of unable to, incapable to, which is the higher standard that we associate with the defense to the crime itself. And I think, that's a really important distinction here, and why we are talking about this not as a trial and a direct appeal from a trial, but why this was a case that resolved in a plea agreement with the ability to raise a departure motion, because of that distinction and what the evidence was that was before the court, and why it is so fundamentally important that the sentencing court is able to look at these factors that are not the legal defenses, but incorporate more in this determination. And I cite 4 particular areas where this has come up throughout these ruling on the departure motion. But at each one of those instances where the district court got on to discussing these mental culpability factors, the impact of that, and what should be a question of whether he was substantially impaired in these areas. You see language like, at the time of the crime, you didn't know the difference between right or wrong, or that you were not able to control yourself, which are insanity tests. Those are tests to the guilt question. They are not the question of whether or not there's a substantial impairment to his ability to appreciate the criminality of the act. It was whether or not he was incapable to or could not. You see language.
Counsel.
Yes.
Just let me see if I've kind of gone back. You look at the motion, the evidence, and then how this argument or this legal distinction that you're talking about has progressed over time in the record. Is it fair to say that the motion itself didn't draw that fine of a distinction between the standards either? In other words, when describing the evidence, and some of the witnesses that testified in support of departure used language that, as you put it, incapability, conditions that made it incapable of. And so when Judge Ryan then on the record, you just quoted the first statement that you're challenging, but if you read the full paragraph, he kind of starts with, it's argued that. And isn't he simply taking language from the motion, framing it based on how it was framed in the motion? Is that possible?
That, I don't have pin sites to the terms incapable in the motion, but I think that is completely possible. This is tricky terminology here, and I think everyone was less careful than they should have been about that distinction in what was proven there. There's also a difference in the way that counsel and like the party presenting the evidence might be presenting it as reaching a higher threshold than is even required by the statutory mitigating circumstance. You could argue some of those factors were established of incapability given the psychotic delirium evidence and everything in there, but that's not the legal standard that the district court had to apply.
And would you agree that at least initially, Judge Ryan does cite to the precise language in A6 when describing the mitigating circumstance?
Yes, I believe he does.
And then at the end of the day, if there's some ambiguity, is that enough to carry your burden of legal error constituting an abuse of discretion? Right? Because there is a correct pronouncement of the standard, right? And then there's this other language that you've kind of highlighted.
Yes, I think the evidence or the transcript showing that the judge misapplied the test when it came to the discussion of the factors is sufficient to reach the legal error in the legal application of that factor, and to go back for a new ruling on this issue for the judge to make, the judge in this case provided a very detailed and descriptive ruling because there was a lot of evidence in this case and very, I think, difficult and important issues that we're overseeing. And I think it's appropriate to go back to the district court to give the judge the opportunity to rule on the issue, making sure that they are applying the correct standards to factors that the judge highlighted as significantly important to their determination. And again, I can go through the individual statements that I mentioned in my briefing here, but I think over and over in those instances, what we just saw was every time this evidence came up and the district court was reaching its analysis in this area, there was a description, perhaps a misparaphrasing of the standard that the district court was needing to apply here. And I think that impacts, of course, the district court's reasoning, because the district court said these factors were important. It impacts the way the district court might have looked at the evidence, because that impacts what the understanding of what the experts were talking to and testifying to impacts the way the district court evaluates and weighs the strength of what they were saying. And it ultimately, I think, impacted the outcome of this case. And unless this court has any further questions.
Any other questions, colleagues? Thank you.
Thank you.
Mr. Chief Justice, and may it please the court. I'm Jacob Gonteski. I represent the plaintiff, the appellee, the state of Kansas. This case comes before you on a very narrow, specific question of law and that is whether the district court abused its discretion in declining to depart from the standard sentence the legislature has found just for the crime of premeditated first-degree murder. This was not just a premeditated first-degree murder. We can speak of it clinically, or we can speak of it specifically. It was the execution of a pregnant woman and her unborn child. The record shows that the sentencing judge in this case, one with 15 years of criminal justice experience on the bench, overseeing criminal cases, aside from his own experience as a judge in the criminal justice, as an attorney in the criminal justice system, faithfully applied the statutory framework and this court's guidance in navigating the departure motion that was before him. He painstakingly evaluated 13 specific mitigating factors that the defendant put before him. And the judge ultimately and reasonably determined that those factors, whether viewed individually or collectively, failed to force the district court to depart from the status quo. And I use the word force specifically because that is this court's case law on departures. A departure is only justified when the district court is forced to depart from the status quo. Mr. Sublett's argument does not reveal error in this case. Instead, what Mr. Sublett seeks to do is isolate specific phrases from a 23-page oral pronouncement of the court's ruling. Those 4 statements that Mr. Sublett complains of have been stripped of context, and he is essentially asking this court to substitute its judgment in place of the district court. The district court listened to 2 full days of testimony on this departure motion. It heard from witnesses. It heard from a lot of players in this case about the departure factors. Holistically, what this record reveals is that Judge Ryan knew the law. He applied it faithfully. He applied it accurately. The statutory definition of substantial and compelling was in his wheelhouse. It's exactly what he quoted. It's what he applied in this case. It's what he's done dozens of other times. He carefully weighed the defendant's arguments, the mitigating factors that he presented, the claims of trauma, substance abuse, his emotional state, and his family support were all weighed by the district court. The district court even found some of those factors substantial in a lay sense, but found ultimately none were so compelling as to force the district court to depart from the status quo. Particularly in light of the record taken as a whole, the defendant's conduct was seen by the district court justifiably as being deliberate. His awareness in this case when he undertook these offenses was deliberate. His awareness was intact. His flight from these offenses was purposeful, and his concealment of the gun was intentional. The district court's conclusion here that the facts before it did not force it to depart from the presumptive sentence of a hard 50 was not merely reasonable, it was squarely supported by the evidence. 2 lives were taken in an execution-style killing by this defendant of a sleeping, vulnerable woman and her viable unborn child. The sentencing judge examined every mitigating circumstance that was put before him. He correctly recognized that the defendant's background, while tragic, did not compel the district court to depart. The deviation from the sentence the legislature has deemed appropriate for premeditated first-degree murder. Because the district court faithfully applied the statutory framework and this court's guidance on departures, this court should affirm the district court's ruling.
Any questions, colleagues? Thank you, Mr. Gonteski.
Thank you.
Mr. Perkins, you reserve 3 minutes.
Thank you. I don't believe I will be taking those full 3 minutes. But I agree with some aspects of what the state was saying there. That there was a significant evidentiary hearing in this case, that there were 13 mitigating circumstances presented to the district court. And in fact, the district court found a great number of those, either in his terminology, they were substantial or there was evidence supporting them. And then was reaching this question of whether or not those were collectively compelling. but the area where the district court said both that the questions were the most significant and also where the district courts seem to struggle the most in the distinction between mitigating circumstances and substantial impairment as to mental state versus the incapability of understanding the right and wrong. Those are the areas where I believe the district court reached legal error in its analysis, where the district court used terminology that had it been a prosecutorial statement in closing argument to a jury, I would raise that as legal error, where I think the district court that gave a uniquely thorough opinion on a very difficult question where there was a significant amount of evidence. I think that's the exact scenario where it is important to define the lesser standard of substantial impairment that's relevant to the mitigating circumstance, the distinction that gets lost a lot between substantial impairment and substantial incapacity or substantially incapable, and to give the district court the opportunity to rule with the full understanding of the legal question before it.
Any questions, counsel? Colleagues, thank you. Counsel, thank you for your arguments this morning. This appeal will be taken under advisement.